My name is Jane Fishman. I'm a county court judge in Broward County, and I'm here to tell you a little bit about what to expect in small claims court. A small claims case is a legal action filed in the county court to settle minor legal disputes among parties where the dollar amount involved is $5,000 or less, excluding costs, interest, and attorney's fees. Forms that have been approved for statewide use are located within the Florida Small Claims Rules. The clerk of the court may also be able to provide you with copies of appropriate forms. A small claims action begins by filing a statement of claim with the Broward County Clerk's Office. Filing fees for small claims actions are established in the Florida statutes and local county ordinances and are subject to change by legislative action. The clerk of court will be able to provide information on the filing fees. After filing, each person or business who is being sued, the defendants, must be served with a summons or notice to appear in court on a date and time scheduled when the initial claim was filed. A copy of the statement of claim should be attached as provided in the small claims rules so that the person or business being sued knows what relief the person who's bringing the lawsuit, known as the plaintiff, is suing for. Additional fees are required for service of process on the parties being sued. Generally, service of process will be made on the defendants by the Broward Sheriff's Office. In Broward County, the clerk of court will schedule a pretrial conference at which all parties must appear. If the defendants have been properly served and fail to appear at the pretrial conference, the plaintiff may be entitled to a default and a default final judgment. The judge presiding at the time of the pretrial conference may ask questions or require the plaintiff to produce documents in support of his or her claim, including proof that the defendants are not in the military service. The court may prepare the judgment for the plaintiff. However, the court does not collect the judgment. The clerk can provide you with information regarding the recording and collection of your judgment, or you may wish to engage counsel for that purpose. The Broward County Bar Association does have a low-cost lawyer referral service that you may wish to use. If the plaintiffs and defendants both appear at the pretrial conference, the presiding judge is likely to send both sides to mediation right then with a trained mediator who is in the courtroom. The mediation service is free to the parties, and it's designed to help litigants resolve the issues between them fairly and quickly. Typically, at the start of the pretrial conference, the presiding judge will explain the process to all the litigants and introduce all the mediators present. Then the judge will call up each case individually and ask the person being sued, that's the defendant, if she or he owes the money that the plaintiff, the person suing, claims is owed. If the defendant says no, or says that he or she owes some but not all of the money that the plaintiff claims is due, the judge is likely to send the parties out with a mediator. The mediation process enables the parties to confer fully about the case, negotiate details of a settlement, and it is hoped reach a resolution that will be written up by the mediator. Usually this will be a stipulation for payments and will detail the amount of the debt, the amount it is being settled for, and the amount and frequency of payments. If the parties reach an agreement that requires the defendant to pay all or part of plaintiff's claim, the plaintiff will also be able to recover from the defendant the court costs that were incurred in bringing the lawsuit. If the parties do not settle the case at mediation, the judge will set the matter for a trial. It's important that the parties understand that at a trial, they cannot introduce a statement from a witness, a letter, an estimate, or an affidavit from a witness, because those things cannot be questioned by the other side. The parties will have to bring the witnesses and evidence that they wish to introduce to the trial. Also, if a party is claiming that work was done carelessly or incorrectly or negligently, in addition to the party's own testimony, the party may need to call an expert witness to testify in support of that claim. If a party has witnesses that she or he wants to call and is concerned that the witness may not appear voluntarily, the party should go to the clerk of court and arrange to have a subpoena issued and served to require the witness to appear. At the trial, the plaintiff, the person who is suing, will be required to present evidence first, since it is the plaintiff that has the burden of proving his or her claim by a preponderance of the evidence. The judge may ask questions of any witness and may permit the defendant to ask questions of the witnesses. After the plaintiff presents all of his or her evidence and witnesses, it will be the defendant's turn to testify and present evidence. All parties and witnesses must direct their testimony to the judge, not to each other, and are also expected to let every witness testify without interruption. After the judge has heard all the evidence, the judge will issue a ruling. That may happen in open court immediately after the trial has concluded, and at that time the judge may offer the parties another opportunity to enter a payment plan to avoid entry of a judgment. Or the judge may take the matter under advisement and enter a judgment at a later date that reflects which party won the case and how much the losing party must pay the winning party. In addition, the judge may order the losing party to fill out a fact information sheet that contains personal information designed to enable the judgment holder, the party who won the case, to collect on the judgment. It is important that you understand that the court will not collect the judgment for you. If you are the winning party, you must pay to record the judgment, and you may need to seek collection remedies such as garnishment to get the money you are owed. You can find out more about how to collect your judgment from the Broward County Clerk's Office. Good luck and enjoy your day in small claims court.